What has to happen here is this case has to be tried in this court. We're not saying this case is not going to be tried in this court. They want to try it in the media.
Non-parties, the children, and even the parents. But it's not to protect DFS. And that's essentially what they're doing. We have filed a lawsuit alleging that DFS has done wrong. And so they shouldn't be able to hide behind the statute every single time.
Would counsel who's present please identify yourself for the record?
Good morning, Your Honor. Paola, Armeni, and
Good morning, Your Honor. Nadia, Ahmed.
for Mr. Eggleston.
Good morning, Your Honor. Felicia Galati, appearing for Georgina Stuart and Clark County.
Okay, and we've got defendant's motion to stay plaintiff's state law claims, and there's also a motion for leave to file exhibits under seal. Let's go ahead and hear the motion for leave to file exhibits under seal. Just looking at them, they didn't appear to be things that I really did need to seal.
Here's what I'll tell you, Your Honor. I'm sure you've read the papers. Of course, we're relying on NRS 432B.280. We're relying on the SRCRs. We're relying on CAPTA, the protective order, and Kamakana. So what I did today, because I think Judge Spells, if I remember right, had asked us to submit an exhibit or exhibits to her unredacted. So what I did was I actually brought copies for everyone, and they already have unredacted copies, but what I'm saying is I brought a copy for Your Honor to look at, and I would like to make argument on that, but there is specific information in there regarding mental health, medical conditions, medications, diagnoses, criminal history, child abuse investigations, not just this one, but others. So I did want to make submissions regarding that particular exhibit, which is Exhibit C to the motion to stay. When we filed the motion, we redacted the entire contents because the details of it really aren't relevant to whether the case should be stayed, because the basis for the stay is the pending judicial review petition. However, based on what happened at the last hearing, I brought the clean copy, and so I can either submit it to Your Honor to look at in chambers and you can see the conditions, or I can also highlight some of the conditions for you. But if I'm going to provide details regarding the medical history, I'd like that part of the hearing to be sealed because it involves all non-parties, the plaintiff mother, I'm sorry, not the plaintiff mother, the mother of the children and the children.
Okay, I was going to say, why do we need to discuss those with respect to your motion to stay? I mean,
I'm sorry, I thought you said seal.
Well, we are doing the motion to
Okay.
seal,
Yeah.
But those are in support of the motion to stay.
Correct.
Okay.
That was just to show that there were underlying DFS conditions for you. But if I'm going to provide details regarding the medical history, I'd like that part of the hearing to be sealed because it involves all non-parties, the plaintiff mother, I'm sorry, not the plaintiff mother, the mother of the children and the children.
Okay, I was going to say, why do we need to discuss those with respect to your motion to stay? I mean,
I'm sorry, I thought you said seal.
Well, we are doing the motion to
Okay.
seal.
Yeah.
But those are in support of the motion to stay.
Correct.
Okay.
That was just to show that there were underlying DFS proceedings that were dealt with finally at the administrative level and now are pending before the first district on the petition. So yes, you're right. Substantively, that's why I redacted the whole thing. They weren't relevant to that. But I did want Your Honor to know that there were underlying findings, which are the subject of the judicial review petition and also the subject of this action. So if you don't want that, that's fine. But there are certainly mental health, medical, medication, information regarding the minors, other child abuse investigation, a call to police, et cetera, stuff like that. I just don't want to get into the details because they're non-parties and because they're minors, not knowing what Your Honor's position is.
Okay. Hold on a second. I'm trying to find. One problem I'm having is parties are not giving me courtesy copies, and finding things is a little tough in the record, especially one that's as big as this one.
Do you want me to give you this exhibit? I can also give the plaintiff the copy of it. I have extras.
Well, does this go back to March?
Yes, the motion was filed in March.
Okay.
March 11.
Okay. Well, the ones you got are redacted.
Right.
Here, I see that. Okay. Ms. Armeni?
Your Honor, just briefly, this case, as I mentioned in our pleadings, is bigger than Mr. Eggleston. In civil rights actions, we're looking also at the case can affect the public in general. And I think we always have to keep that in mind, whether it's the resolution of the case becomes a deterrent or it affects policy change. And so this is, I know that we're looking at this through, and Ms. Galati keeps talking about NRS 432B, I think, sorry, I can't read without my glasses, 0.280. And I understand what that statute says. But this is not, we're not in the middle of a child abuse neglect case down in family court. This is where and that statute is to protect, I agree, the non-parties, the children, and even the parents. But it's not to protect DFS. And that's essentially what they're doing. We have filed a lawsuit alleging that DFS has done wrong. And so they shouldn't be able to hide behind the statute every single time. Do we agree that there are some things that are probably private, subject to HIPAA, subject to other federal estate rules? Yes. However, that doesn't mean you get to do a blanket redaction or a blanket sealing on everything. Kamakana requests compelling reasons supported by specific factual findings. The defendants have provided cases to the court. However, they haven't provided specificity. So in other words, they said the district court, and I don't remember if it was, I think Magistrate Judge Cope sealed documents in this case, but we don't know what the underlying documents were that were before Magistrate Cope in which she sealed them. So we've just been given sort of a blanket statement. In these cases, they've sealed. However, we don't know what they've sealed. And, are they akin to the documents that are being sealed in this cases? There's just no particularized showing. The exhibits, a lot of them, as the court noted, correspondence, things like that, they can simply be frankly, I think all the documents can be unsealed. I think the only one that perhaps they have an arguably could be sealed is the investigation report. But that investigation report, although this motion for stay is a very small portion of the case, that investigative report is relevant to the whole, this whole matter that's before the court. It is a material issue. And the problem I have is that we're getting these declarations from counsel and other people, and they're picking and choosing from these documents that are supposed to be sealed, which I understand they have a right to defend the case, but then it puts us in a position that only small portions are getting out in the public, not the totality of the circumstances. So we have a concern with that. I think that there are ways to support what the defendants are saying and to get what they're trying to get done without just a blanket, we're going to seal everything that's filed. Because I think this is just the start. I think we're going to start to see if this motion is granted today, every time a motion is filed, everything is going to get sealed. And I just think because this is a civil rights case, we have to keep the bigger picture in the back of our minds when we're looking at these things. And for those reasons, I would ask that you deny their motion.
Your Honor, the fact that this is a civil rights case does not change the analysis here. We are duty bound to comply with the statute 432B.280. And as a result, that's why we filed this motion. We routinely file it with respect to all these cases. The statute is clear. It says information maintained by the agency which provides child welfare services, including without limitation, reports and investigations made pursuant to this chapter is confidential, period. It starts with that. These are documents and information maintained by the Child Welfare Agency, which relies on federal funds under CAPTA and must maintain the confidentiality of those documents. That's why we filed the motion. We do it every time. Certainly, Your Honor can make the decision in this case, but that is the starting point. There is no basis, just provided no basis for you not to follow the statute. There are no cases that say if it's a civil rights case, well, you get to see everything and hear everything. That doesn't happen. I can tell you as an officer of court, we have cases in federal court routinely, which are civil rights cases, and the records get sealed. I'm not telling you that you have to do that, Your Honor, but I'm just telling you that that's what happens because of the statute, because of Kamakana, because of the CAPTA. But the bottom line is, counsel misspoke. The standard is not compelling reasons. It's good cause under Kamakana. Good cause. The statute provides good cause. The protective order provides good cause. But what is most important is we're talking about non-party minors and a non-party mother and their child abuse investigations, medical conditions, mental health conditions and medications, and the public has no right to know that. And that is not, and what has to happen here is this case has to be tried in this court. We're not saying this case is not going to be tried in this court. They want to try it in the media. That shouldn't happen, but fine, there's a media order and Your Honor's allowed publication. That's fine. You know, we accept that. But at the end of the day, these minors and this mother, their private information should be protected. And the legislature enacted the statute, and we can't ignore the statute. We have to comply with the statute, and we're going to have to comply with the statute with every filing. So I'm just telling Your Honor that the statute is clear, and there are clear interests that should be protected, people who are not even involved in this case. What I mean is as parties.
Okay. I don't know that I have a problem sealing some things, but there's a lot of forms that you're asking me to seal. Why are we sealing the forms and when I say forms, I'm talking about like part of Exhibit A is the procedures on appeal. Why are we doing that?
You don't have to seal that part. What we do is we take everything that is a DFS document information because of the statute, and we request that it be sealed. If Your Honor doesn't want to seal the rules or any other part of that, that's fine. I'm going to leave that to Your Honor. But I think what is key is that Exhibit C.
Is Exhibit C?
Yes.
Okay.
But that's been redacted, so that's why I wanted to provide Your Honor with an unredacted copy so that you could look at it, not right now, but you could look at it and you can see what I've just told you is correct. There's all kinds of medical, mental health and other conditions in this that should be protected.
Okay. This is what I will seal. I'm going to look at Exhibit A, the February 2nd letter itself by Georgina Stuart. That will be sealed. That's Eggleston 000735. The information about appeal of substantiated abuse and or neglect findings, that's Eggleston 000736 through (741). That will be that will not be sealed. Exhibit B will be sealed.
I'm sorry, did you say Exhibit B unsealed and then sealed?
That will be sealed.
Sealed?
Exhibit B will be sealed.
Thank you.
And just so that I am clear, there's no bait stamp on that one.
Is this the one that's dated August 27, 2015?
Yeah, I wish I had a courtesy.
No, I have it here.
Okay. Well, that doesn't help me
I know.
right now.
Well, I can tell you what's on there. If you're on to Exhibit...
What? Okay. Exhibit B, which is a request for agency appeals, received February 12th of 2015, is sealed.
Thank you.
Okay. Exhibit C will be sealed. And we need an unredacted copy that is filed under seal.
Okay, I'll do that.
Because certainly Ms. Armeni should be able to see it.
Oh, yeah, she has all unredacted.
Your Honor, I respect that, but at the same time, I'd like to see what goes to the court.
Of course.
I think that's fair.
Sure.
To be
I have no
courtesy
problem.
copied.
Okay. Exhibit D will be sealed. Oops. Is that D? Now we're getting into, hold on. Yeah. Got an Exhibit K.
That's the supplemental disclosure, Your Honor, but I think that I'm sure Ms. Galati will correct me. I think the investigation report was attached to the supplemental disclosure. So I don't necessarily think the supplemental disclosure needs to be sealed. It's the attachment.
With respect to Exhibit K, pages 1 to 2 is the plaintiff's supplemental disclosure. I have no problem with Your Honor unsealing those pages, but pages 3 and following are DFS documents that we're still requesting be sealed.
Well, guess what? Exhibit 3 is not attached to Exhibit K.
Exhibit 3? No, I'm saying page 3.
There's no page 3. I'm sorry.
Oh, I'm sorry. Hang on. Let me go to K. And print it.
Okay, well, there's no page 3, so Exhibit K will be unsealed.
Is that just a disclosure, Your Honor? I'm sorry, I thought I printed it, but I didn't.
Okay, it's 2 pages. Whatever the 2 pages that it is it's the Plaintiff 16.1A1 supplemental initial disclosures dated April 30, 2018.
Okay, I have no objection to that being unsealed. Sorry, yes, not being sealed.
Okay, Exhibit L, except for the first page of Exhibit L, which is Eggleston 000196, which shall be sealed, but all the other information that is done later, and that's 000197 through 202 will be unsealed. Okay, what else was it?
I think you covered it, Your Honor. It was A through D and then K and L, but my only concern, I'm going to go against what I just argued in light of the court's ruling, but I do have concerns with leaving the affidavit or the declaration of, I think the DFS employee, because she basically says, this date, there was a substantiation letter, and this is what was found. So she's saying, even though we're sealing the letters, her declaration, and that is,
See, I'm going to tell you right now, I'm having trouble finding it.
you have it, I'm sorry?
I only had that one document. Okay, so when was that?
It's Exhibit E, Your Honor.
Okay, Exhibit E.
Is the declaration.
When was it filed? I don't have it.
March, with the motion to stay on March 11th.
March 11, okay. I see the motion to stay right here.
And it is an affidavit from a Crystalline Minwigan Johannesson. She appears to be an employee of the Clark County Department. She's a family services supervisor in the legal unit of Clark County Department of Family Services.
So you're asking for those to be sealed?
Yes, Your Honor, because she basically, you have sealed certain documents, and in her affidavit, she proceeds to explain those documents.
I have no problem
Okay.
sealing Exhibit E. Or, yeah, Exhibit E. Okay. All right, does that take care of that motion?
Yes, thank you.
Yes.
Okay, all right, let's go with the motion to stay. And I'm going to just tell you I'm inclined to deny that. So tell me why I should stay something waiting on what happens in the first Judicial District Court.
Sure. I know that Your Honor's read the paper, so I'm going to try to just do an overall global argument for you and answer any questions that you have. Essentially, the amended complaint in this case relates to an underlying DFS investigation, proceedings, and various hearings, including a fair hearing, which is an appeal at the highest level in the DFS administrative structure. So that's what this relates to. And the plaintiff is seeking, has a civil rights claim and has state court claims regarding that matter. At the same time, after that after the plaintiff went to the highest level, the fair hearing at DFS in the administrative proceeding, he filed the petition for judicial review, seeking to review the decision made below, which is pending before the first judicial district. And after that, while the appeal to the Nevada Supreme Court was pending, the plaintiff sought a stay of the judicial review petition. So the Nevada Supreme Court, once it decided the appeal, entered its order, including the footnote, indicating that with respect to the tort law claims, it appeared that the DFS case was at issue and that plaintiff disputed the findings of child maltreatment and that a stay may be appropriate. So it was based on that we pursued a stay, first trying to meet and confer with the plaintiff, and then, of course, we filed the motion. So it's our position that the judicial review petition must be decided first, because that will be the final decision as to the administrative decision finding child maltreatment, which is the subject of this case, because depending on the outcome of the judicial review petition, we may file a motion to get some relief to dispose of some of the claims. whether it's issue preclusion, claim preclusion, or something else. I'm not saying that, you have to decide today and that's going to work. We don't know. We have no idea what the decision is going to be. So that's why we're asking that you stay this, because depending on what the first district decides, we may have a basis to file a motion which could dispose of some claims and would be most efficient, certainly for this court, certainly for us, and certainly a savings of attorney's fees incurred by the county. And I can tell Your Honor that based on all the papers that have been filed, it appears that Ms. Armeni has already submitted an order to the First Judicial District to lift the stay. I don't know if that's been signed or not signed yet. But then if it's not opposed, so my guess is the court would sign it. I don't know, we'll see. But once that's signed, then the petition can proceed to a determination of the constitutional and civil rights claims that the plaintiff made in that petition.
Okay, so the Supreme Court case came down in October of 2021. Are you saying that the petition is still stayed in the First Judicial District?
Yes.
And you're wanting me to stay this case because that case is stayed?
No.
Why has not that been lifted as of October?
That's a question for the plaintiff.
So, Your Honor, normally I would imagine when the Supreme Court, basically nothing's happened in the First Judicial District Court as a result of that, the Supreme Court finding or opinion, and perhaps it's because they weren't provided notice of it. I'm not sure what the case was. So we sought a stipulation to lift the stay from the DFS, different attorney than Ms. Galati, but DFS. DFS refused, so we had to file a motion to lift the stay. That is currently pending before the First Judicial District Court. He has not ruled on it yet. But my memory is there is an opposition to it because she wouldn't stipulate.
Okay. Absolutely not true. And in fact, I think you have Ms. Dorman's order. Yes, true that she did not initially stipulate when Ms. Armeni contacted her in February of 2022. I will note that the Supreme Court issued its order in September. While Ms. Armeni did not come on the case until November, somebody should have lifted the stay. The plaintiff should have lifted the stay himself. If he wasn't going to lift it, it should have been lifted in November, not now. But anyway, they filed their motion. Yes, Ms. Dorman filed a response, but I understand it was not an opposition. And then Ms. Armeni submitted an order to the court because it wasn't opposed.
No, that's not true.
Wait.
Sorry.
I'm listening to the counsel first.
Because it wasn't opposed. And so that order is before the First Judicial District to be signed as lifting the stay. I'm not saying it's been signed. I don't have any information about that. But my information is that she did submit an order to the court, and it got rejected because it didn't comply with the rule and had to be resubmitted. Whether they resubmitted it, I don't know, but that was recent. And I can tell you, Your Honor, one second.
She did file a response. I'm
sorry.
I'm sorry. No, I didn't mean to do that. I didn't realize that she wasn't done.
No, I'm not finished.
I heard the pause.
I'm looking for Ms. Dorman's affidavit. What did she say? She filed a response, not an opposition. Otherwise, why would she submit an order for the court to sign if it was opposed?
Okay.
I'm just trying to find Ms. Dorman's affidavit. I'm sorry, Sharon. Here we go. So, our supplement, try to get you the date. We filed our supplement on 5/26/2022, and it's Exhibit B to that supplement, where we have Ms. Dorman's affidavit.
Now, that was filed with the First Judicial District Court.
No, in this court. Our supplement to the stay that Judge Spells indicated the parties could each file a supplement.
Okay, let me get that.
Sure.
And it was May
26th.
Okay.
So Exhibit B is Ms. Dorman's affidavit. She's counsel for Clark County in the judicial review petition. So let me see if there's anything in here. There might not be anything in here. Yeah, there's nothing in here. So my information comes from Ms. Dorman that, and actually I think it might even be in their supplement. The last paper they filed. One second, Your Honor. I think there's an affidavit from Ms. Ahmed that that addresses what they've done.
Yeah, I was gonna say, there's nothing in that affidavit.
Yeah, no, it's, one second.
I'm happy to discuss with the court the status of both cases, Your Honor.
Okay,
And I have their opposition in that case,
okay.
or their pleading in that case. Your Honor.
Okay.
Called a response?
Called a response.
Yeah, thank you. If she wants to go ahead, I'll look for Ms. Ahmed's affidavit, but she can go ahead if that assists her.
Counsel?
Thank you, Your Honor. Your Honor, so just to frame this discussion really quickly, Your Honor, this is one of the many reasons that the court should deny their motion, but it's the procedural posture of the two cases and the fact that they come to the court asking this court to stay the state tort claims here while they know that the case is stayed there and in fact have gotten in the way of allowing that state to be open. So what happened, Your Honor, is Mr. Eggleston was pro per in that case. In this case was dismissed. This case went to the Supreme Court. Mr. Eggleston sought the stay in that case before that court. They opposed the stay because of this case's Supreme Court review, specifically stating, Your Honor, that here the petition for judicial review is not a related case to the Supreme Court case, as that involves alleged civil rights and alleged tort claims. That's the position they took in opposition to Mr. Eggleston's motion to stay and the petition for judicial review case. It appears that the court orally granted the motion to stay. They claim in their papers to this court and their supplemental that actually no written order was ever entered staying the case there. So I think that they're trying to tell this court there's no actual stay. But, Your Honor, nothing's happened. So we went to counsel here asking if she was stipped to lift the stay in that case. And she said she wasn't counsel in that case. It was, in fact, a government attorney. So then we went to that attorney. She emphatically refused. We've attached her email to us in one of the exhibits, and I can identify that for Your Honor. So then we went back to that court, and we filed a motion to lift the stay. They recently filed an opposition, and Your Honor, everything there is not electronic. We get mailed copies of things, so I do, Your Honor, have it, and I could provide it to the court, the opposition that they provided to us there. And that opposition, they call it a response, and they say two things. They say, Your Honor, it appears that the court stayed the case, but the court never entered a written order. That's their first point. And their second point is that, well, first he said he wanted to stay it, and I don't know why he's changing his mind now. And that's their full argument that they put in their response. So they never say in their response, we agree the stay should be lifted in that case. So that's where we are now, Your Honor. The court in that district asked both parties to provide proposed orders to the court. We provided a proposed order. And just yesterday, the day before, the court there reached out to Ms. Dorman saying, we've yet to receive your proposed order. So the status of the case there, Your Honor, as I understand it, is it's stayed. It's been stayed. There's a pending motion to lift the stay we filed when we took over Mr. Eggleston's representation in that case, which was in March of 2022. He was pro per until then. So that pending motion, we believe will be imminently decided, but as of yet, it has not been decided. And as of now, our proposed order is with the court, and the court is waiting for their proposed order. And they will essentially, I think, Your Honor, decide and sign one of the two proposed orders. So as of now, that case is stayed. Here, they're seeking to stay the state tort claims. And so that's just where we stand on the procedure in both courtrooms. I don't know if you were done. I don't know, Your Honor.
Can't get anything.
And Your Honor, Ms. Armeni was just reminding me that one of the quirks of being in the first Judicial District Court is that literally we can't access any of the case online. And so we filed a motion to appear in that case so that we could access the docket. When we did that, we still haven't even been able to access the documents or the docket either online or in person. And they recently opposed our motion for access to the docket. And I'm going to defer to Ms. Armeni.
Yeah, I just want to clarify, just so the court knows, we have had some stumbling blocks. We've tried, and so they're actually not online, which is a problem. So everything is mailed to them. But what had happened was we reached out to the clerk of the First Judicial District Court and said, you know, we just want a copy of the docket just so we can see what's going on in the case. And they said, okay, well, you need to file an appearance. We filed an appearance. We called them back and we said, okay, we filed an appearance. Will you please give us access to the docketing statement so we can just see what's going on with this case to determine if there was in fact a stay, if there was an order, what was going on. And so when we said that, they said, no, that doesn't work either. So you're going to have to file a motion. So basically we filed two motions blindly, one giving us, we filed a motion for access to the case. So us as counsel of record could know what was going on. and then we filed the motion to stay simultaneously. So there's been some hiccups for us. It's not, we're not dragging our feet. As the court knows, Mr. Eggleston was pro per. He is now in England, so trying to get documents and get up to speed as to the posture of the case was our first goal. And then we have had some of these struggles with the First Judicial Court just because they're not online, because that case is sealed. And even being counsel of record, I don't have any access to it.
Thank you. All right, it is your motion, so go ahead.
Thank you, Your Honor. Attached to Ms. Dorman's affidavit that you were looking at earlier is a docket for that case. You can see from the docket there is no stay order. I don't know how it works up there. I would have expected there to be some order, but no one has provided an order. Whatever. I'll accept that it stayed. The plaintiff's attorney says that the court told him it was stayed and nothing's happened, so presumably it stayed. But also there is an order before the court. I think I've already pointed out, Your Honor, that counsel was on this case since November. But if plaintiff's counsel couldn't do anything about it, then plaintiff should have done something, because he was perfectly capable of filing his petition while he was in England and perfectly capable of dealing with whatever had to be dealt with, including getting the stay. He's the one who got the stay. He got the stay because of the appeal. The appeal comes back. Does he lift the stay? No. Eventually he retains counsel. Okay. Why does it take that long to file a motion to lift the stay? I believe because they didn't want to lift the stay, because they knew we were going to use that and maybe make the county look bad. Okay. Maybe that's true. Maybe it's not. Whatever. At the end of the day, a number of months have passed. He hasn't lifted the stay. But the bottom line is those claims that are pending in the first under the judicial review petition are the same claims that are pending in this court. Civil rights violations, constitutional violations relating to the underlying DFS proceedings. And that's why we're seeking a stay, for that decision to be made so that we can then decide whether we can dispose of some of the claims here on a dispositive motion.
Thank you. Opposition?
Yes, Your Honor, thank you. Your Honor, the bottom line is that position is factually and legally incorrect. As the court knows, having done petitions for judicial review, there's a very narrow issue being decided in the First Judicial District. That narrow issue is whether under NRS 223B.135, petitioner can show clear and convincing evidence that there was a substantial right that was violated, and there are 5 different prongs under which he might be able to seek relief as to that specific DFS finding substantiating abuse. It's a very narrow issue. It's a closed record. The record has already been submitted to the court. The only issue is whether he can meet this huge burden on that petition for judicial review. But Your Honor, the point here is plaintiff continues to throw out these terms, claim preclusion, issue preclusion, or something else, is what she said today, that might allow them to file a dispositive motion here if the court waited for the ruling there. That's not true, Your Honor. As we put in our opposition on page 5, it was filed, Your Honor, March 25th. In that opposition, at the bottom of page 5, we lay out the elements of the state tort claims. They do not overlap with what needs to be proven in the petition for judicial review case. There's not a single element that's the same. There would be no claim preclusion. There would be no issue preclusion that would let this court dispositively decide the state tort claims, even if that case went first. So, Your Honor, for that reason, we ask the court to reject their motion. Secondly, Your Honor, there's no judicial efficiency achieved by granting the motion because that record is finished. Here, we're trying to move forward through the discovery and develop the record as to our state tort claims, alongside the record on the 1983 claims. Those claims, Your Honor, are all inextricably intertwined. They all relate to the same conduct, which is not specific to the DFS substantiation finding. We did put facts in our opposition, Your Honor, because the case history demonstrates why that's so. This case, the claims arise from the removal of the children from the home, which preceded the substantiation finding, which was issued by DFS. That is one narrow point of evidence that will be at issue in the civil rights claim. It is not an element as to any of the causes. And so for that reason, Your Honor, it wouldn't allowing us to proceed with discovery on the state tort claims while we develop the case in the 1983 claims is the most judicially efficient route. Because otherwise, Your Honor, what I foresee happening is constant return to the court trying to carve out where we stop on our civil rights investigation and depositions and written discovery, while because there's a stay as to these other claims, it's not judicially efficient. What would be judicially efficient is allowing all the claims to move forward and to allow us to develop a discovery as to these claims, because at the end of the day, whether that petition for judicial review is denied or granted, there will be no ability to find claim preclusion or issue preclusion as to state tort claims here, because there's no matching elements or claims at issue. So, Your Honor, it's not judicially efficient. It's not legally, there's no legal basis for waiting. They don't really make the showing that it's required to stay a case, which is a huge showing, precisely because courts want to see cases move forward and move to resolution. This is a case, the subject matter, which dates back to 2015, Your Honor, and it involves a man who was separated from his 2 children. So we would like to see progress on this case. We, since getting on the case, Your Honor, have moved forward as efficiently as possible. We continue to move forward with discovery. We would like to move forward in vetting those state court claims. One of the things, Your Honor, that arose at the hearing, the last hearing that happened in May, was that there is a default as to two of the defendants who are non-government actors, the people who actually took the children. And so there's a default, so there's not a default judgment yet. They actually appeared, it seemed, Your Honor, I was sitting in the courtroom, and we put this on the record in the last hearing, they were in the courtroom, they checked in, at least one of them did. Brian Callahan checked in. Your Honor, one of the points that we made in our opposition was that there are other defendants in this case. Staying the tort claims as to Clark County would be inefficient, given that we have other defendants who, again, there would be no dispositive motion regardless as to any of the defendants, but certainly a stay shouldn't reach those other state defendants. And so then you have a stay just as to one state tort claim defendant, but not a stay as to the other state tort defendants. Again, it's judicially inefficient. Finally, Your Honor, we also noted that what this issue that we spent most of the morning discussing, Your Honor, we noticed the hypocrisy, essentially, Your Honor, of the position that Clark County is taking. It's the same defendant. I understand that they had a government attorney in the other case, and they have a private counsel here, but nonetheless, it's the same defendant, and they have an obligation to present to this court a consistent and honest position. So they come to the court asking for a stay here, pending that case, when in that case, they have gotten in the way of every effort to lift the stay. So now they're saying, well, no, we didn't submit an opposing order because we want the stay to be lifted. But they've never said that. When we asked them, will you step to stay, to lift the stay? They said, no, we refused. When we filed a motion to lift the stay, they filed a response that doesn't clearly say anywhere in there, we agree, the case should be lifted, the stay should be lifted. They're not in good faith telling that court, let's lift the stay. And they're not in good faith coming to this court and saying the stay makes sense, because it can't make sense when that case is stayed and this case is stayed. So, Your Honor, the end result, and I don't put this on counsel, but the end result is that Clark County gets a boon of dragging this case out forever. So it's legally unsound. There are no elements that match. It's judicially inefficient, and they don't come to this court in good faith given the prior positions they've taken. Specifically, Your Honor, in their pleading, which we attach as Exhibit B to our supplemental, which was filed on May 24th, 2022 in this court, they specifically say in that opposition to the motion for stay in the first judicial district, again, Your Honor, I already said this, but I'll say it again. The petition for judicial review is not a related case to the Supreme Court case, as that case involves alleged civil rights and alleged tort claims. So Clark County took the position previously that these are not related matters. They come to this court now asking to slow down and essentially stop half of this case, now taking the exact opposite position, telling this court that it's because that case is dispositive of elements and claims in this case, and that is not legally correct. For all of that, Your Honor, we would ask that the court deny the motion.
Your Honor, I'm going to ignore counsel's personal comments regarding hypocrisy. Having said that, what counsel said in what she just read, again, by other counsel for DFS, not me, was that the Supreme Court appeal was not related to the judicial review petition. That doesn't mean this case is not related. There was a finite issue before the Supreme Court, which was the exhaustion of administrative remedies that we got the dismissal based on. That was the issue at the Supreme Court. So she was correct when she said that the petition didn't relate to that. Nonetheless, plaintiffs sought and got the stay despite the opposition. So where are we? We have a judicial review case filed by the plaintiff regarding the DFS proceedings and findings. It's pending up there. Plaintiff got the stay. Okay. Nothing had been done to lift the stay, either by the plaintiff himself before he was unrepresented, and then It wasn't until most recently that council started making efforts in about February to lift the stay. So council says it was very difficult. I accept what she says. I accept it was maybe not as easy as an electronic court like this where we can just file things or do things, but there's many ways to do things. I've practiced up north, not in that district, but in another district. It's not that hard. You either, mailing is inefficient because it's slow, but you can pay a processor or a company to take something to the court and file it and get it right away. Here's an idea. If counsel couldn't get the docket, and we've provided it to the court because it's one of our exhibits, well, the plaintiff could get the docket because he's the plaintiff. Did that happen? Apparently not, because they said they weren't able to get that document. But at the end of the day, what happens in that court, which has the right to make decisions regarding constitutional issues and civil rights claims, is relevant to this case here, because they are challenging the findings and they are using those findings to support their constitutional and civil rights claims. For those reasons, it should be stayed. And again, it was plaintiff who put the stay in motion. It was plaintiff who sat back and did nothing, maybe took a long time to hire a lawyer, and then things weren't happening efficiently. It doesn't take that long to file a motion to stay, Your Honor. It doesn't have to be that complex. It could be 2 lines. Oh, we got to stay because the Supreme Court had an appeal? Well, guess what? The Supreme Court made a decision. Here's the decision. How hard is that? It's not hard. Plaintiff could have done it, or it could have been done sooner, and it wasn't. So that's not on us. At the end of the day, he got the stay. He put that in place. He needed to lift it. It didn't happen. And again, what's going on up there is relevant to what's going on here. And today is not the date to make a decision on issue preclusion or anything else, because that hasn't been briefed. So the issue here is whether the case should be stayed. And plaintiff has controlled the judicial review petition from the start.
Unfortunately, the First Judicial District Court probably did not receive the remitter that was issued in this court. And as you know, I'm a new judge in this case as well. Counsel, in looking at all of this, and I did read your briefs, I just didn't go through the history of all this and all the supplements and so forth. I'm familiar with some things because I did review some things, but in any event, I'm going to deny the motion to stay. In my view, I can't wait until another court does something. We don't know whenever they're going to make that decision on a petition for judicial review, and that is an appellate process. So there's already been a decision made at the lower level, so they're just making a decision whether or not it should be affirmed or reversed. So I'm denying the motion for rehearing motion to stay. I see I've got a motion for rehearing on July 12th. I have not read that one yet. Just so you know, we've got a status check on trial readiness in November, and then the trial I've got set on a 5-week stack commencing February 6th of 2023. I'll be able to let you know where you fit on that stack, give you a sense of the trial readiness status check in November. In fact, let me just kind of look where we are right now. I've got 14 matters on that stack. I've got a medical malpractice firm, but gosh, since you're a 16 case, you're going to be number 2. So we'll be able to give you a firm setting, I'm convinced, at the pretrial conference calendar call, which will be in January. Okay?
Can I ask Your Honor 2 things?
Sure.
About housekeeping. The motion for rehearing doesn't need to be heard because you've heard the motion. So it's sort of mooted. So you could take off that date in July that you mentioned. I forget what the date is.
Okay, it's July 12th.
Yeah.
We can vacate? All right,
Yes.
Let's go ahead and vacate that.
And then this was filed before this case came to your court, Your Honor.
Right.
So we filed a motion for leave to file the motion to disqualify the judge under seal, and attached to that was the motion to disqualify. After that, Judge Spells recused herself, which is fine, but this motion for leave needs to be addressed, in other words, granted or denied, so that the motion to disqualify can be filed under seal, which is what we asked for,
Okay.
to protect the judge.
Right, now that decision would be up to the chief judge.
Okay, so how do we get file a request for the chief judge to decide it?
You know, I will go ahead and contact the chief. Of course, the chief changes as of tomorrow.
Okay.
Okay, but you're asking for a decision on, you don't think that the decision is mute because
No.
Judge Spells has disqualified herself?
No, I don't. And because we have a right to file the motion, and it was the motion that she read to make the decision for the recusal. I'm not saying it has to have a hearing date. I just need the record to be clear of everything that was filed. So something is either filed under seal or not filed under seal. We asked for under seal. I would assume that the court would grant filing that under seal because it contains private information regarding the judge, and that's why we asked for it. But I just want the record to be complete.
So are you
regarding
just
that.
asking me, now I think I can make a decision whether or not things go under seal,
Okay.
but the motion to disqualify
Oh, yeah.
itself is something that the chief or the chief's designee has to make a decision on.
I'm not asking for a decision on the disqualification because the judge recused herself. I'm asking for a decision on the motion for leave to seal the motion to disqualify because I want the record to be clear regarding filings.
Okay, by the way, do you have any problem with the idea that I decide the motion to seal as opposed to, I'm not making a decision on the recusal?
No, Your Honor, we have no issue with your authority. We think it's moot, but we'll submit it to the court.
Okay. Because I certainly don't think that we need to have personal information about the other
Right.
judge in
Yep.
that case.
Agreed.
Okay. But I'm going to just tell you though, in my view, I'm pretty transparent. I think you kind of figured that out whenever I went through each page of what you requested to have sealed. I want to look at every page on that thing as well. So, plus there's some things that are out there in the public. I think some of the things you've got in there is a newspaper article because I just happened to see it.
Yeah, that. But so we deferred. What's the word? We wanted to be deferential to the judge, and we certainly didn't want to cause her any. I don't know what the word is, but we wanted to protect privacy, even though that was in the media. But a lot of the other things were not in the media. Were confidential documents at DFS. So that's why we just went ahead and put the whole thing under there. Whatever Your Honor wants to decide is fine, but as a matter of housekeeping, I do need a decision on that, just so that the record is clear. If you seal it, it gets filed under seal, great. If you don't seal it and tell us we have to file it, then we would file it, just so that the record is clear what happened before the judge recused.
Okay, I'll take care of it.
Thank you.
All right, and I take it you guys will prepare the order and then get it to defense counsel?
Your Honor, do you want us to prepare the order on both motions, or would you like?
Actually, that would be, I think that would be good. I mean, there was a partial sealing, but some things were not sealed. But did you get the exact page numbers that I wrote, that I had my court clerk?
I did my best to follow along. Hopefully between me and Miss Ahmed, and then we'll run
We
it by
can
Miss
work it out.
Galati. Yeah, we'll run it by Miss Galati. I'm sure between the three of us, we have it ready.
Yeah.
Okay.
Can I just ask another question?
Sure.
So when we submit orders to your inbox, once it's, we've gone through that process, I take it that all parties must be included in any communications with the court when we're submitting orders?
Well, I don't know how it
Okay.
happens. I just know it happens,
Okay.
It gets submitted, we review it, and so forth.
We always CC counsel. I'm not gonna. Our process is to CC counsel. I'm not saying we don't make mistakes along the way, but we don't ever talk to chambers without CCing counsel.
Well, and typically the orders, the proposed orders, we want them signed off or a reason why they're not signed off.
Sure.
So you would know if you signed off on it.
Well, something happened in this case. It doesn't matter because I'm not going to take an issue with it. But I understand that an order was submitted and I didn't know the order was submitted. But it doesn't matter. It's done.
Okay,
To be
well,
clear, it's
hold-
not related to me.
No, absolutely not. Absolutely not.
Okay, well, just
I just
so that
want
you
her to
know,
it's not us.
Andrew's my law clerk, and Andrew, don't we ensure that both parties either they've signed off on it, or if there's a refusal to sign or something like that, then fine, that is in the record. But we send them back if they're not approved as to form and content or a reason for the lack of approval.
Well, there was an indication of not response. Again, I'm not asking for any relief. We did respond, but apparently it wasn't received. So anyway, I'm just saying, I just want to be clear that everybody knows, even people who are listening and recording this hearing, that orders, and I'm sure Ms. Armeni knows this, and I accept that she would send it to us, that if an order is submitted to Your Honor for signature, even if, let's say, somebody didn't approve it or whatever, the parties have to be included in that. That's all I'm saying.
Okay. All right.
Thank you.
All right. Thank you.
Thanks.
Thank you, Your Honor.
Mhm.